This courtroom hearing is a masterclass in controlled chaos. What you're about to watch isn't just a routine pretrial appearance. It's a collision between self-representation, constitutional arguments, procedural timing, and a judge, who is clearly not here to play games. The defendant walks in confident, citing statutes, amendments, and case law by name, attempting to dismantle multiple charges before the case even reaches a preliminary examination. But here's the twist. Knowing legal buzzwords isn't the same as winning legal arguments. This case raises critical questions. When does a hospital become custody? Can charges be dismissed orally before evidence is reviewed? And how far can a defendant push constitutional claims before the court draws a hard line? Stick with this hearing, because what begins as legal sparring quickly turns into a battle over control of the courtroom itself, and the judge makes it very clear who has the final word.
7, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid.
That were going to be addressed. That would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further, in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2.
This is the defendant's first major legal swing, and it's a technical one. He's arguing that the escape from custody charge is invalid because he was physically located in a hospital, not a jail or government detention facility. On paper, that sounds persuasive. Michigan statutes do define custody narrowly in some contexts. But here's the problem. This is not the stage of the case where factual sufficiency gets decided. The judge shuts this down immediately, not because the argument is impossible, but because it's premature. That's a key lesson in criminal procedure. Courts don't dismiss felony charges based on oral arguments before testimony and evidence are presented. That's exactly what preliminary examinations are for. The judge isn't saying the argument fails. He's saying, this is not the time. In timing, in criminal law, is everything.
257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenge the prosecutor to prove all 3.
Sir, do
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed. A motion for all dismissal on all these charges.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Ms. Lundy has let me know that all paper discovery has been sent to Mr. McLuhan in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McLuhan. I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten
Here we
the
see
video.
the defendant escalate, shifting from statutory interpretation to constitutional firepower. Fourth Amendment violations. lack of notice, insufficient proof. He even challenges the prosecution to meet every element of operating, while license suspended, but the courtroom reality check comes fast. Motions to dismiss are not granted simply because someone claims violations. They require written filings, evidence, and argument at the proper procedural stage. The judge makes something very clear here. Oral motions don't override process. This is where many self-represented defendants stumble, confusing legal theory with legal procedure. The courtroom isn't debating hypotheticals, it's managing a process designed to test those claims later, under oath, with witnesses. And the judge refuses to let this hearing turn into a trial before
Coming
the trial.
down to the jail to him.
I expected you would have him early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th, and then
have him in well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination as being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be
This
subject.
exchange exposes a real tension in criminal cases. The right to a speedy trial versus the right to full discovery. The defendant wants to move forward immediately, even without video evidence invoking his constitutional rights. But the court recognizes something crucial. You can't meaningfully challenge evidence you haven't seen. Discovery delays aren't uncommon, especially when multiple agencies are involved. The judge balances both sides here, ensuring the defendant receives all materials before the preliminary examination while keeping the case moving. This isn't a denial of rights, it's protection of them. A rushed hearing without evidence doesn't benefit justice, and the court refuses to let speed come at the expense of
By up
fairness.
to 93 days, $500 fine plus court costs. There is, however, a third offense notice, which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. The court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I will. I have requested assistance given that I am
Now, the
incarcerated.
gravity of this case fully hits the record. The judge methodically lists each charge, penalty, fine, and potential incarceration term, and suddenly this isn't abstract law anymore. Felony, fleeing and eluding, operating without insurance, driving while license suspended. And then the big one, third offense OWI, which transforms a misdemeanor into a felony carrying years of incarceration. This breakdown serves a critical purpose. The court must ensure the defendant understands exactly what he's facing. This isn't intimidation, it's constitutional due process. And for viewers, this moment clarifies why the judge is treating the case with seriousness. These aren't paperwork violations. These are charges that directly implicate public safety.
That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. If that is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge. Torture Feaster, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Good. Well, Your Honor,
This is one of the most important moments in the hearing. The judge pauses everything to address self-representation, and his warning is blunt. Representing yourself isn't bravery, it's risk. Courts are required to advise defendants of the dangers, and this judge does not sugarcoat it. No special treatment, no leniency for mistakes. Full knowledge of court rules required. This is the judiciary protecting the record, making sure no one can later claim they didn't understand. The consequences. When the defendant finally says yes to legal assistance, the tone of the room shifts. The system steps in to stabilize the process. Public defenders aren't just lawyers. They're safeguards against procedural collapse.
Over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness. Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate, and then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf, and for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
In response from the people regarding his bond.
People would ask the bond to continue, and he also at the bench for failed to appear before the judge's claims. So
yes,
that warrant would also hold up with respect to the other. I'll wait.
Here, the defendant launches his most complex argument yet, alleging unconstitutional delay, citing Supreme Court precedent, and invoking multi-pronged tests for prosecutorial fairness. On its face, this sounds sophisticated, but again, substance matters more than citation. Courts don't grant bond modifications or dismiss charges based on untested claims of delay alone. The prosecution responds with the practical reality. The defendant is already being held on another case, has failed to appear previously, and faces charges involving flight and intoxication. Those facts matter. Bond isn't about punishment. It's about risk. And from the court's perspective, the risk profile here is simply too high.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
that's what I would.
But I would,
Mr. Curtis,
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And
I understand the presumption.
This is where judicial authority becomes unmistakable. The judge explains, calmly but firmly, why bond modification is denied. Risk of flight, nature of the charges, public danger. This isn't personal, it's structural. And when the defendant continues pressing innocence and facial invalidity, the judge responds with a legal truth many defendants struggle to accept. Claims don't equal proof. Charges stand until evidence defeats them. Courts don't rule based on belief. They rule based on process. This moment defines the balance of power in the courtroom, and the judge reasserts control decisively.
Will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity.
This hearing delivers a clear message about how the justice system actually works.
Because I
Legal
think that's
arguments must
precisely
follow
what he
procedure.
wants to have
Constitutional
happen.
claims must be proven, not proclaimed. And attempting to outmaneuver the system through filings, accusations, or pressure tactics won't derail a case without evidence. The judge denies bond modification, rejects recusal attempts, sets the preliminary examination, and keeps the case firmly on track. Whether the defendant's arguments ultimately succeed will depend on testimony, evidence, and law, not courtroom theatrics. If you found this case as intense as we did, hit that like button, share your thoughts in the comments. And don't forget to subscribe for more in-depth jaw-dropping courtroom breakdowns.